Didier, thank you very much. Ladies and gentlemen, good morning. I've been asked to talk for just a few minutes today about the legal aspects of a topic which has become depressingly familiar in recent years, the post-2008 collapse in new building values across almost all the main shipbuilding sectors, and the widespread economic distress that this has caused to ship owners and shipyards alike. As most of you know from personal experience, the last 10 years have witnessed an extraordinary roller coaster ride in world shipping, comprising 5 or more years of ever-increasing shipbuilding prices and the consequent rapid development of huge additional shipbuilding capacity, particularly in China, followed by an almost equally wild crash in prices and values as credit and thereafter demand for new ships has substantially declined or evaporated altogether. Now, I'm not sure I'm going to win many friends this morning by saying that these have been relatively good times for shipbuilding lawyers. In common with other birds of prey, we lawyers usually survive quite well in feast and famine. And whilst work on new projects, new shipbuilding projects for my firm has obviously declined since 2008, we've seen a very substantial increase in demand for assistance in relation to distressed projects. These are what I call those shipbuilding programs for one or more ships still under construction, where the market value of the vessel or vessels has significantly declined since the contract award, so that the ship owner is unwilling or even possibly unable to take delivery of the vessel. As specialists in this area, we've been involved in literally dozens of recent cases in which the level of economic distress has been so great that the lawyers have been called in, either on behalf of the shipyard, seeking to enforce the agreement or to preserve by renegotiation as much value as he can, or on behalf of the ship owner, seeking to renegotiate or possibly to cancel. As just one example, we're currently assisting ship-owning clients who placed a VLCC order in Korea in 2008 at approximately $150 million US, and they're now faced with an expected market value on delivery next year of something in the order of 85 million. Finding long-term financing to pay the delivery installment against that sort of background in this financial climate is, as we say in England, like trying to get blood from a stone. So what I'm intending to do this morning is to discuss some options open to the purchaser of a distressed new building and to briefly consider some of the factors which may influence the choices he might wish to make. Before doing so, however, I should make clear that even in a bad market, most purchasers of new buildings go ahead and take delivery of their vessel at the original contract price. The reasons for this are various. The purchaser may be concerned about his reputation if he's seen to default and the shipbuilding contract is cancelled, or he may have a long-term relationship with the shipbuilder which he doesn't want to prejudice. He may also have in place a time or bareboat charter for the vessel and is not in a position to cancel unless he has the charterer's prior agreement. This may be achievable in this sort of market in relation to a vessel which is easily replaceable in the marketplace, but the charterer's consent may not be forthcoming if the vessel is specialised, has been built specially for his trade, and that's particularly the case we see in the offshore oil and gas sector, where we're very active. But I'm obviously not looking at this situation, the situation where the owner goes ahead and takes delivery. What concerns me today is the situation where the ship owner is not willing or not able to go ahead because of significant market decline. Now, it may not always be a wholly moral position to try to walk away from a contract, but as we all know, business is business, and one must always bear in mind that during the period of market boom between 2004 and 2008, many Western ship owners faced the converse situation. Shipyards, particularly in our experience in China, were demanding substantial price increases as a condition of delivery of vessels which had been contracted below the market value at the time of their delivery. Now, the first and most important point to bear in mind in looking at this subject is that a decline in new building values in itself is not a circumstance which, at least as a matter of English law, will assist the shipowner. The English law of contract is firmly based on the Roman law principle pacta sunt servanda, and there is no entitlement in our law, as there is under the national legal systems of other countries, including Italy, to seek a release or even a readjustment of contract terms on the grounds that the contract has become much more onerous than the parties originally envisaged. So there's therefore normally no right in the shipowner to claim that circumstances of market collapse have constituted events of force majeure, or that these in some manner frustrate the shipbuilding contract in the same way that other events, for example a declaration of war, may sometimes operate in English law to release both parties from the contract. And in too many years of doing this job, I've never come across a contract clause in a shipbuilding context which provides for the builder to share the financial pain resulting from market collapse during the course of the vessel's construction. The parties may sometimes be willing to share the currency risks or the risks of physical loss or damage during construction, but the downside market risk is almost invariably borne by the shipowner, who's not entitled to a price reduction or given the option to cancel simply because the market has fallen away. Equally, the shipowner alone bears the risks that for reasons beyond his control, the financing he's arranged for the vessel's purchase may be withdrawn because of market disruption. We're currently assisting more than one shipowner who's facing the possibility that in the event that the Eurozone is unable to resolve Greece's debt problems, the financing commitment he has taken from his local Greek banks will simply not be honoured. So what can a shipowner do in this situation? In other words, how can he protect himself from a situation in which he will otherwise take delivery at a price which will generate an immediate book loss and which may also start to generate for him trading losses from day one? A great deal will obviously depend upon the factual circumstances of each case, but there are a number of factors and principles at play which are worth considering. Plainly, the situation in which the shipowner is best placed is where he has or can generate a right to terminate the shipbuilding contract because of the shipbuilder's default. Where, for example, the shipbuilder is substantially and inexcusably late in delivering the vessel, or the vessel fails to meet the minimum parameters for speed, deadweight, fuel consumption, and provided that there is in place adequate refund guarantee security, the shipowner will in effect have an option whether or not to take delivery of the vessel and significant scope to renegotiate the contract terms if he wishes to do so. Furthermore, depending upon the factual circumstances, the shipowner may, in light of our recent Stocznia Gdynia decision of our Court of Appeal, possibly be in a position to claim damages in addition for the loss of the contract, as well as receiving back his instalments and interest. Because the financial crisis has made trading conditions equally difficult for shipowners, we've been involved in several cases in the last couple of years, in which in circumstances of shipyard default, shipowner clients have been able to renegotiate contract terms as an alternative to cancellation. I have to say we've also been involved in numerous instances in which shipowning clients have behaved slightly less than completely honourably, and by refusing to overlook defects and problems with ships which they would never have raised in the period before September 2007, the shipowners have generated a situation in which cancellation for delay has become possible. But this is a dangerous game. There are a number of legal arguments in English law available to a shipyard seeking to prevent an owner from cancelling a new building for delay in delivery, and London courts and arbitration tribunals are, in my experience, reluctant to allow owners to play the market by seeking deliberately to delay delivery of a vessel which is largely contractually compliant. So where we're dealing with the alternative situation, and this is, in my experience, the usual situation, the shipyard is not in actual or potential default, which would entitle the shipowner to cancel. The shipowner's position is obviously much weaker. In this situation, much greater importance attaches to commercial rather than legal factors. In particular, the nature and length of the commercial relationship between the shipowner and the shipbuilder, and the extent of the shipowner's financial involvement in the project, in particular the amount of the instalments, the aggregate amount of the instalments of the contract price he has previously paid. Most of the successful commercial negotiations in which I've been, renegotiations in which I and my firm have been involved in the last 18 months, have involved a situation in which the shipowner and the shipbuilder have a long-standing relationship and a mutual long-term benefit in ensuring that the shipowner can firstly take delivery of the vessel and then he can trade her with at least some financial return. Where there's no such relationship, but the shipowner has paid in a relatively limited proportion of the contract price, there may also be some scope for renegotiation. In my experience, shipyards do not like reselling cancelled new buildings into the marketplace. It reflects badly on them as well as on the owner. And then having to pursue the defaulting purchaser for the balance of the contract price. It sometimes is the case that where the owner has not paid in a significant proportion, the prospects of renegotiation increase. But again, it all depends upon the facts and the parties involved. Finally, just a few words about the renegotiation process. In my experience, certain factors are of particular relevance. Firstly, it's extremely important to preserve confidentiality. The Korean shipyards in particular are very concerned not to be seen to be offering concessions to Western ship-owning clients, and it's vital that their need for confidentiality is respected if the renegotiation is going to succeed. Secondly, it's much easier to persuade Asian shipyards to agree to a deferral of new building delivery dates than it is to secure simple price reductions. Where reductions have been obtained, these are usually disguised in some manner, often by the reduction in cost of previously agreed variations to the specification, rather than by a simple decrease in the headline contract price. Thirdly, it's obviously much easier to negotiate contract cancellations where these relate to part, but not the entirety, of a multi-ship new building order. We've seen at least 2 instances in the last 18 months in which Korean shipbuilders have been willing to agree that later ships in a new building series should be cancelled and the signing instalments paid in respect of those ships applied to meet outstanding instalments due in respect of earlier vessels in the same series. So if you're in the unenviable position, the unfortunate position of holding a distressed shipbuilding contract and you want or need to do something about it, the very best of luck to you. As a first step, I suggest you hire yourself a good shipbuilding lawyer. Thank you very much.